There are a number of things that you might not know could happen if you get stopped for a breathalyser test at the side of the road. Knowing what's required of you will make sure you don't accidentally fall on the wrong side of the law. The police are generally able to stop any person driving a motor vehicle on a road. You should pull over if the police ask you to do so. It's a criminal offence not to stop your car when required by the police. You might need to have your driving licence ready to show the police. If you don't have it with you, you might be asked to bring it into a police station as soon as you can. You might be asked to pass a breathalyser test. The police also carry roadside drug swipes, which can tell from your saliva if you have certain drugs in your system. The police can't ask you to give a preliminary breath test unless they have reasonable cause to suspect any of these things. Number one, that you're currently driving or in charge of a vehicle with alcohol in your system. Number two, that you've been driving or are in charge of a vehicle and you still have alcohol in your system. Number three, that you are or have been driving or attempting to drive or in charge and you've committed a moving road traffic offence, for example, driving carelessly or speeding. In practice, this often means that the police will stop drivers who are swerving, speeding, or missing traffic signals, such as red lights. You might be asked to do a field impairment test. This is a physical test, you've probably seen it on US cop dramas, to see whether your balance or your spatial awareness or your perception of time is impaired, to see if you're drunk. The police will be writing down notes about what happens at the roadside in a booklet. Remember, anything you say will likely be written down in these notes. If you fail a breath test at the roadside, you'll usually be taken to a police station where the police will take an evidential sample. This means they'll attempt to take a sample of either your breath, your blood, your urine, one of those for scientific analysis. And this allows the police to know exactly how much alcohol or another drug is in your body at the time the sample was taken. At the police station, you'll be asked to give 2 samples of breath, or have a nurse or healthcare professional take a sample of your blood or your urine. If the sample is of blood or urine, the police will always offer you half the sample to take away so you can have a lab test yourself if you want to do it. If your breath alcohol is above the legal limit, which is more than 35 micrograms in your breath, then you'll be charged with a criminal offence, driving whilst under the influence of alcohol. That's Section 5 of the Road Traffic Act, 1988. There are lots of requirements for how the police has to go around taking these samples, including a warning about what will happen if you refuse. The police have to comply with these very strict rules at all times. You won't usually be interviewed for a drink driving stop, but you will be under caution and your comments will be recorded. You should do what the officers ask and answer their questions honestly. Many people don't realise that it's in fact a criminal offence to refuse or fail to give the police an evidential sample of breath, blood or urine when they ask for one without a reasonable excuse. That's Section 7.5 and 7.6 of the Road Traffic Act 1988. Failing to give a sample includes not blowing into the breath machine when requested, or indeed give 2 samples. Refusing or failing to give a sample without a reasonable excuse is just as serious as if you were found to be drink driving. If convicted of failing to give a sample, you can be imprisoned for up to 6 months or receive an unlimited fine. You'll also be disqualified for at least 12 months. A reasonable excuse for failing to give a sample usually only means a genuine medical reason. You should expect to be able to prove this with evidence if it ends up going to court. It's down to the police to decide which kind of sample to ask you for: blood, breath, urine. You can't decide which you'd rather give. Being scared of needles is probably only going to count as a reasonable excuse if you have a medically diagnosed fear which you can prove. What if you're found guilty of drink driving? Well, if you're convicted of drink driving, you can receive an unlimited fine or up to 6 months imprisonment in the very worst cases. The court must endorse your licence with the conviction and disqualify you from driving for a minimum of 12 months. The disqualification period can actually be a lot longer than this, and it depends on how high the level of alcohol in your body was when you were stopped. It also depends if you've previously been convicted of drug driving before. You might be offered the chance to complete a drink drive awareness course by the magistrates, and if you complete one, it'll reduce the length of time you spend disqualified from driving. If you plead guilty, you'll receive a credit or a discount to your sentence. It starts at a maximum of a third off if you plead guilty on the first possible occasion. That's section 144 of the Criminal Justice Act 2003. I hope you found this video useful. Please do subscribe to this channel if you did. I've got a huge number of legal explainer videos. You can see more criminal law explainer videos here. There are some employment explainer videos there. You can subscribe down there, and just here is a video that I think you might like. Thank you so much for watching. Bye bye.